The Maternity Benefit Act, 1961. A boon for working women. In this video we will understand following of the Maternity Benefit Act, 1961. Eligibility. Maternity benefit payments. Duration of maternity benefit. Important compliances under the statute. Penalty for non-compliance. Biggest challenges? And before continuing, don't forget to subscribe and press the bell icon for latest updates. Let us first understand Maternity Benefit Act 1961. This is among those few acts that are applicable even in the state of Jammu and Kashmir. This act applies to every establishment being a factory, mine, plantation, or any other such establishment where the persons are employed for exhibiting equestrian, acrobatic or any other performance. The Ministry of Labour and Employment, Government of India, Ministry of Labour, via the Official Gazette notification dated 31st of March 2017 has appointed the 1st of April 2017 as the date on which Maternity Benefit, Amendment, Act 2017 has come into force. Eligibility for maternity benefits. A woman must have been working as an employee in an establishment for a period of at least 80 days in the past 12 months as per Section 5(2) of the Maternity Benefit Act, 1961. Duration of maternity benefit. The Maternity Benefit Amendment Act has increased the duration of paid maternity leave available for women employees from the existing 12 weeks to 26 weeks as per the provisions of Section 5. Under the Maternity Benefit Amendment Act, 2017, this benefit could be availed by women for a period extending up to a maximum of 8 weeks before the expected delivery date, and the remaining time can be availed post-childbirth, before continuing further. We thank you for subscribing our YouTube channel, The Hotelier. And if you haven't subscribed yet, please subscribe for latest updates on hospitality and human resources. And don't forget to comment on this video. Duration of maternity benefit. The Maternity Benefit Amendment Act has increased the duration of paid maternity leave available for women employees from the existing 12 weeks to 26 weeks as per the provisions of Section 5. Under the Maternity Benefit Amendment Act, 2017, this benefit could be availed by women for a period extending up to a maximum of 8 weeks before the expected delivery date, and the remaining time can be availed post-childbirth. Important compliances under the statute. The compliances and forms are prescribed by state-wise maternity benefit rules. We have taken the example of Punjab to illustrate the number of compliances applicable in case of Maternity Benefit Act to establishment engaged in a particular state. Muster roll shall be maintained by the employer in Form A as per Section 20 and 28, 2A, read with Rule 3 of Punjab Maternity Benefit Rules, 1967. Notice of claim for maternity benefit by the woman employee to the employer in Form B as per Section 6 of the Maternity Benefit Act 1961, read with Rule 4 and Rule 6 of the Punjab Maternity Benefit Rules, 1967. Proof of pregnancy, delivery of child or miscarriage provided by a medical officer in Form C as per Sections 6(5) and Rule 28(2)(e), read with Rule 5. Nursing breaks of 20 minutes, provided that in case the creche or place where children are left by a woman while on duty is not in the vicinity of the place of work, a period up to 15 minutes may be allowed for the purpose of journey to and from creche or the place as per Section 11, read with Section 28(2)(1), read with Rule 7. The abstract of the provisions of the Act and the rules shall be exhibited in Form K in a conspicuous place by the employer in every part of the establishment in which women are employed as per Sections 1 and 28(1). Read with Rule 15 of the Punjab Maternity Benefit Rules, 1967. The employer shall supply to every woman employed by him at her request free of cost copies of Forms B, C, D, E, F, G, H, and I, annual return on or before the 21st day of January in each year in Form L, M, and O as per Section 28(2)(k). Read with Rule 16. If the employer of an establishment to which the Act applies sells, abandons or discontinues the working of the establishment, he shall, within 1 month of the date of sale or abandonment or 4 months of the date of discontinuance as the case may be, submit to the competent authority a further return in each of the said forms in respect of the period between the end of the preceding year and the date of sale, abandonment or discontinuance. Penalty for non-compliance. Section 21. Offense: employer failing to pay any amount of maternity benefit to a woman entitled under this Act. Punishment: punishable with imprisonment which shall not be less than 3 months but which may extend to 1 year. Offense: discharges or dismisses such woman during or on account of her absence from work in accordance with the provisions of this Act. Punishment: punishable with imprisonment which shall not be less than 3 months but which may extend to 1 year. Offense: in case of employer contravening the provisions of this Act or the rules made thereunder. Punishment: he shall be punishable with imprisonment which shall not be less than 3 months but which may extend to 1 year, and with fine which shall not be less than 200 rupees but which may extend to 5,000 rupees. Offense: failure to display abstract of Act US 19. Punishment: imprisonment may extend to 1 year or fine US 21(2). The biggest challenges: the employer has to provide full wages for the period of maternity leave to the employee. The employer has a statutory mandate US 11A of the Act to provide creche facilities in case the number of employees is 50 or more. Unlike other countries where the state shares the cost of providing such benefits, in India the cost is to be borne by the employer himself. Every woman returning to work post-delivery is entitled to 2 breaks in the course of her date to nurse her newborn until she turns 15 months old. However, these breaks remain unexecuted in most cases. Provision of a creche, especially for smaller organizations which lack the financial resources for the same, is a challenge, until there are alternate businesses in the economy to whom this responsibility can be outsourced. Although the Equal Remuneration Act prohibits discrimination in remuneration and other terms of employment between men and women, the long duration of maternity leave, 26 weeks, and fully paid, applicable for up to 2 children, is a huge deterrent for several organizations in hiring female candidates, as it increases their financial costs significantly. Further, organizations view this requirement, coupled with the POSH Act, as being specifically onerous on them. Thank you for watching. If you have any query, please comment. We will try to resolve your query as soon as possible. And also, if you want a video on any topic related to hospitality and HR, then please comment. Maximum comment on a topic will be covered in our upcoming videos.